Good afternoon, ladies and gentlemen. How have you enjoyed your weekend? I've been serious about the assignment I posited in last class between Leonid David and Lenin. Okay, then in this class, we have a final review about a civil system, titled Merger or Destitute of Divisions. And for next, we will advance to a common law traditions, and a historical wake of evolution, and through some of a devolution tendency, and also finally a distribution of the tradition across global jurisdictions. So let's get on the final touch of a civil law tradition. The words come from a English scholar named Wire. He has put in a distinction to make between transactions and collisions. And the first viewpoint would come from a fluctuating variety of human activity upon which the legal classification is imposed. So, as a civil law scholar, how do you assess the rigid inflexibility of legal system on a traditional rubric of a basic codes and genres and also? Do you agree if it can pose challenge to the basics of humanity? The argument may revolve around some sociological viewpoint through the conjecture system, fundamentally, and so we may enchant some context of a realist viewpoint, which is very strong through the Anglo-American intelligence. As you see, the realist perspective also prevailing in the political science of Anglo-Saxon countries. An idealistic viewpoint would be a more positive across the sectors of interest from this continental tradition, basically. So how do you? Then we can see a legal classification long hatches through the continental system might be artificial constructs in some point, and it can never completely contain the fluctuating variety of human activity. However, it does not necessarily diminish their utility. That there will always be a definitional problems about where they begin and end, about what is included or excluded. The distinction between public and private law, civil and commercial law, contractual and delictual responsibility need not be shown to impermeable or to have an inherent logic in order to functional for various purposes, not the least of which is pedagogical. So the public versus a private contrast has long been strong, but in some cases you might see the ways of approach where a U.S. jurist may come rather a practical beyond the genres. It is strongly embedded in a Roman tradition also, but they see that the approach could well be evolving to accommodate the changing societal needs. How do you agree? Thus, it is likely that however much some parts of contract may merge with certain areas of intellect, there will still be, as Weyerhaeuser put it, a distinction to be made between transactions and collisions. Similarly, though civil and commercial law have fused in many ways, it is probable the commercial law will continue to be studied as a separate subject, and that it will tend to practice mainly by a specialist. The civil law classification that is most eroded by time and events is the fundamental dichotomy between a public and private law, but that survives in the court system in the minds of civil law lawyers. As we have observed throughout this course, intervention by the state in areas once reserved by a private activity increasingly blurs the public-private law distinction. Yet the French comparativist Lund David wrote in the 1970s that in contrast to public law, which is described as subject to the vicissitudes of change and a political crisis, the civil code seems to French private lawyers to be the most lasting and the only true constitution of France. There is indeed a sense in which the civil code is constitutional. The law of civil code is the area of the law in which the function of government is limited to reorganization and enforcement of private rights. So this sense and perception could be vindicated on practical reasons and historical wake of a development in European politics. As you see later, in the common law tradition, there has a long, intense struggle between the king's power and the power of noble class. And in the process, the parliament could act on behalf of a dominant class, and also the court system was influenced by the interaction of the power struggle. So this viewpoint has a precision and extent of reason to see the historical wake of European politics. To say, for the French comparatists, the civil code and the area of civil affairs should be surely preserved for the judicial domain. And the other public areas are largely submissive to the extent of a public power, a king and Congress. How do you agree? So, especially in the field of contract, the civil codes impose few rules in the name of public policy. Most of the law contracts is of type the civilians call dispositive, suppletive, or directory, as opposed to compulsory. Dispositive rules apply only if they have not been expressly or impliedly excluded by the parties. However, one can maintain this constitutional view of civil codes only if one ignores the effect the statute law has had upon them. Special legislation has been an institutional bypass through which the codes have been left intact but emptied of much important content. Legislation outside the civil codes has first and foremost undermined the constitutional function of the codes by establishing a new and competing set of premises. While freedom of contract still appears to be a fundamental principle of civil codes, a variety of mandatory provisions and prohibitions have been introduced by statute in the name of public policy, which in some cases means protection of the weaker party, in other cases the effectuation of economic planning, and in still others the promotion of interests of organized groups. In the area of property, the codes still promote the notion that the law of government is to protect a private property, while special legislation qualifies the property right by subtracting elements in the public interest or modifies it by adding a social obligations. So you are well learned about the area between the mandatory rules in the civil code and elective rules to be applicable absent the contrary agreement between the parties. So they may be derogated by a specific provision or agreements made specifically to address the contractual relationship. And also you can learn the concept of land property, immovables, which is a basic and fundamental to sustain the national economy. So it has to be submissive and adaptive to the critical needs of a public policy. So land may be regulated to the interest of a public and the national policy. So the absolute command derived from a sanctity of property established through the bourgeoisie revolution could be well eroded in to a high extent of a public intervention, as you see. So with the development of public and private insurance schemes, the intellectual liability is no longer the main source of compensation for personal injury. There's now a wide overlap between private tort law and public social security law. The stability which is so characteristically associated with the civil codes appears as an illusion when one taking into account that all this legislation is frequently amended. Indeed, the volatility of the special legislation is often cited as a reason why the civil law cannot be reintegrated into codes. The contraction of the area which is left for regulation by civil codes is not the only a manifestation of the expansion of public law. Administrative law, the child of the 19th century, came into its own in the 20th century. Not only did new areas come under regulation, but government's role in providing social services increased. The public agencies that are created to perform these services have often appropriated private law means and institutions to do so. In the process, the distinction between public and private is further blurred. Also, the state's increased role in the economy not only modified the civil law of contract, tort, and property, but has led to new kinds of economic law, regulating competition, the structure and activities of enterprises, and employer-employee relations. As more areas of public concern are identified, such as protection of the environment or protection of health and safety in the workplace, the scope of administrative law continues to expand. Still, as Dave's characterization of the French civil code shows, the distinction between public and private law has a firm hold on the minds of civil law lawyers. For that reason, even if it is vague or dissolving, it remains important to the understanding of the civil law tradition. So, I like to present a final remark in this context, and you may have a substitute of a extensive discussion in this brief comment. Then, our next topic should be concern of a common law tradition. I prepared a picture to show an engineer your mind through the shrubs of a forest of a communal tradition. Above, you can see a Mount Carta, which is imprinted on stone, very in condensed fashion, and they also bear some Latin letters. If the document is traced back as early as a 2012 or 15, and the document represents a symbolic product for the modern democracy. However, the true nature of this document may well be argued if we have a modern eyes to look through the context of democracy. To say, actually, many viewpoint suppose that this document is a product to protect the interest of a noble class. So the feudal prestige is a place to interplay with then a king, John, and oppress him to forcefully to sign the document to preserve a feudal interest. But actually, that tradition may be relayed into the bourgeois class, which is capitalistic in nature, and some classes to own a production means as a dominant class. And of course, you can see the context of three estates, which typically expose major classes in the history around the years of advent toward a modern democracy. So clerks and clergyman and feudal landowner, another a newly rising class of called a bourgeoisie. So the struggle between a king and a noble class through the British political history is meaningful to have some insight and a viewpoints about a current institution of a modern democracy. For example, we can understand the context of evolution involving a parliament, and also curious regis as also antiquated form of parliament in the British history. And of course, you see later in this course, the separation of powers was not sternly practiced in during the medieval years. So some judicial function and lesser power was absolutely amenable to the dominance of monarch. And I'd like to show the scene of court exchequer. It is caricature and pictured to reveal the process the jurists are acting in the court of exchequer. It is one of three eminent communal courts which have a significance and a great implications to let us understand the the interplay and evolution of a communal judicial system. They have expanded their role and scope of jurisdiction to demolish the 100 courts, which is provincial in basics, and one of a revenue sources for the barons. This story also was entangled with the production of Magna Carta, document of Magna Carta. So barons collect their income from 100 courts, but the king's court, which is viewed as a communal antecedent, and now also working through the communal judicial system. Interact each other, and actually the British history reveals invigorated and some of a living context to expose us some practical understanding of our dynamism. So actually, the public policy also has a fundamentals in the British tradition, kind of a centralization and also devolution of power, and the balance between the government and society are also conceptualized through the process of a historical evolution. So we can derive some insight and also a substantial nature of a public policy and institutions from the British tradition. So the kind of understanding between formalistic and a substantial may pertain to the distinctive element between the European continent and a Great Britain. So in this system, I have divided into many subsections for your attention. So there are lots of topics which would be expected to touch on briefly. We begin with Roman occupation, and there is a period what I call Anglo-Saxon period. Actually, Great Britain is an island, and the influx of a continental populace creates the basis for the nation. For example, from 16 through from 4 through 6 centuries, there was a high extent of influence from Anglo-Saxon area. I am prepared to show you the map to have the ideas, a geographical idea about this influence. But Anglo-Saxony is one region located in the northern part of the European continent, and the populace on that basis shows high mobility through the island. So the Scotland, the region of Scotland, largely filled with the populace. traveled from a European continent to, and that tradition also now a factor that Scottish legal system are largely based on a civil law, a tradition. And the southern part of England was conquered by Norman Duke, was called a Williams, and he is a duke who has a province in northern part of France now, and he invaded southern England and established a king's investiture in the country. Of course, there is a prehistory before the King William conquered England, and some dynasties have been actually the midst of nation, but in rather a mid context, and their power and influence were not so strong against the European powers. And the King William laid the foundation for to establish the feudal structure of a governance. So, genuine context of a feudal system has begun with his conquest, and it is historically so important in terms of a Western civilization. So, along the point through the form national system was created through the centuries of a struggle between king and noble class, and wars of the roses one of significant historical event for the rise of nationalism in Great Britain. And the war was also developed into another war, what I call 100 Years' War. You know, a John d'Arc, and all. So the kings of England actually have a claim for their territory located in various regions of France. So that offers cause for the war, 100 years, and through the years of war of those and 100 years war, France and England have experienced the rise of a nationalism very firmly, and one of a forerunners in the European politics. While we see the development of German nationalism as late as 18th century, and also in substitute they manage the Habsburg dynasty, New Roman Empire, heritage through the conquest of a traditional Roman Empire. So the European history is actually complicated, and we can have a useful traces to understand modern system of a democratic governance, and also basic philosophy we now adhere through the course of our business and daily livings. And you can see Magna Carta. And also, in juridical terms, there can discern many competing jurisdictions until the act of judicature was produced far later in the past centuries. So, for example, ecclesiastical courts have long enjoyment of their exclusive jurisdiction, which is controversial in some cases and also may be overlapped in other cases. And the risk system also a factor to make a destiny between the various competing jurisdictions. It involves a technical issue about how to frame properly frame the cause of action. But actually, its practical consequence is serious among the available jurisdictions. The demise of 100 cause may also offer one cause for Magna Carta, which is document created essentially to protect the feudal prestige of warrior class, what are called barons. And another a notable element, which is interesting, and also still have a say in the common law tradition, what are called equity. There are two basic prongs when we consider the common law tradition. And the equity tradition is fundamental through the civil areas of law in common law countries, and enabled the evolution of separate court system between common law courts and equity court. And their errand or a responsibility is particularly a grandeur, the context of grandeur, to have overhauled the technical dealings of a common law code, and also a grand approach of a equity sense and concept in the name of a absolute power of kings. At the final say about the legal disputes in many cases. And the tradition also produced some remnants that the U.S. private law has held on through. And you can see other code, justice of peace, which is interesting. You can see the background to create to create the justice of peace, the Crusaders' war of the ground to invent this kind of a code. So it has pertinence and some relationship, a very keen context with a majestic code also, which is a very unique form of a criminal code in the British jurisdiction. And also we need to understand some domestic politics through dynasties, particularly Tudors. Dynasty of Tudors and Stuarts are important, in which time the Star Chamber acted very powerfully to support the might of king. So political dynamics and interaction with a judicial branch was practiced, but not in desired way in some context. For example, a star chamber can well be seen kind of a sovereign branch rather than a protection of a human rights also. It is one of a key instruments the king has relied on to preserve and increase his dictatorship in some cases. And the civil law jurist may initiate to implant this Roman tradition, what we call a jus cogens, through the star chamber, but it was hesitant until 9th century reforms, and also the practical factors and the circumstances were adverse in terms of a high level of a common law cause. So the legal system has some interchange, but the societal element would rather be strong. They can now we are unable to see the civil law implant in Great Britain. But through the 19th century reforms, as we have previously learned, the works of Bentham on other utilitarian philosophers urged to push forward the reluctant judiciary into more progressive roles and public responsibility. And finally, we'll be on brief about a distribution. In this context, the Dutch words are enlightening, which gave us a three set of a implant of a common law system. He termed the first instance as seeded, which was realized in India and Hong Kong, and he saw the common law exportation to the United States as settled, the context of settled, which means there is no prior history of a legal system. So they may just emigrated into the territory, and their only work is to administer their laws. Settled. What does it mean by seeded? There is a traditional legal system in the specific jurisdiction. India, Hong Kong has their own legal system before the imperial power of a Great Britain interact. So they lend their superior ideas of law to the country. Then we may define it as seeded, view it as seeded. What is conquer? There is some judicial tradition and may manage their own legal system, but the British power may overrule the existing system by substituting their own common law system. For example, that context may be found in South Africa. Finally, will be available about a Supreme Court of Canada. The jurisdiction is very unique, a mixed context of a Great Britain and a France. So let us advance to each subsection, which must be brief, of course. So English common law evolved from a necessity. The law was rooted in centralized administration of William, conqueror at Hastings. A single event, the 1666 Norman conquest, was the progenitor of this tradition. Its foundation, a unique unwritten constitution, and the recorded but orally rendered decisions of an extraordinarily gifted and respected judiciary. The harmony of a homogeneous society tested by internal stresses, but free of a foreign invasion for nearly a millennium, aided an orderly development of legal institutions. Focusing on the resolution of specific current issues, English law developed insulated from the continental reception of Roman law, and the later emphasis on codification. As Pollock has said, English laws grew in rugged exclusiveness, disdaining fellowship with the more polished learning of civilians. Comprehension of the rule of law in England today and its litmus law in other common law systems calls for an understanding of the cardinal incidents in English history, which were generative of the slow but persistent development of institutions which comprise the common law a tradition. So it is interesting to see the contrast, the viewpoints in contrast. Pollock used the disdaining a fellowship with more polished learning of civilians. His words can be captured in comparison with other contexts, as you'll see later in Star Chamber. The jurist of Star Chamber, ironically, paradoxically, a perception of disdain about a common law tradition. So, how do you reconcile both perspectives as a comparative student of comparative law? So, a Roman occupation is an ancient form of influence intact with a British legal system. English legal scholars trace the origins of English common law principally to the Norman conquest. Legal institutions before the time made few lasting contributions. The early law was unwritten, handed down through generations by oral tradition. We know that over centuries, tribal law changed to go with times, but we know little with exactitude of when the change occurred or the precise forces impelling those changes. Julius Caesar led exploratory expeditions in 1505 and 54 BC to southeast England. Disparate Celtic tribes about whose legal structures mainland has commanded the law of one rude folk will always be somewhat like the law of another. Supported a periodic revolts in Britain against the Roman dominion. A century later, Claudius, timidly seeking status as a conquering Caesar, chose weak Britain to subdue. Romans ruled much of the island for nearly 4 centuries. Britain was marked indelibly with Roman culture. The roads, its road system, the Latin language, and central heating, but the Roman did not bestow upon the inhabitants the Roman legal system. Britain had not been developed. It had been occupied. Roman law was an incident of occupation. It governed relations between Romans, but it began a decline in 410 AD when it appeared that the departing legions would not return. What Rome contributed to the English legal system was indirect, occurring through the survival of remnants of institutional structure of a civilized society. There is a period, what we call Norman hiatus, the Anglo-Saxon period. With the Roman departed, the Britain were left with little but a few Christian missionaries to face Angles, Danes, Jews, and Saxons. Again, society became dominated by diverse tribal communities with low, predominantly unwritten local custom. There was sufficient cohesion for Pope Gregory's missionary, St. Augustine, to establish Christianity in the late 6th century, given English kings the imprimatur of supreme source of justice, but less than divine rights of kings. The latter an important reserve in later centuries. Anglo-Saxon law possessed elements of Teutonic tribal traditions and customs, but personal wealth began to replace blood and kin as the measure of political power. England developed a feudal attitude, but not in a continental sense. Landowners, rather than the community or a community or state, provided protection to and through loyalty from dependent classes. Laws administered justice for the tenants and villeini, and the lands provide a source of taxes to defend the nation. The victory at Hastings by William was more succession than conquest. William's claim to the English throne was no less tenuous than Harold's. The law of England, an aggregate of disparate local customs, was left largely intact by the conqueror. But it confiscated all of the land and then apportioned a possession among his most trustworthy followers, extracting pledges of loyalty and service. William allocated the land in a manner to prevent his barons from concentrating their power and challenging William's central authority. This limited holding of the land, with ownership remaining in the sovereign, is today largely theoretical. So there are actual complicacies in the property law of the United States. The common law system, property law, the understanding of common law property law should be traced to the medieval years, far earlier, and the system evolved in a decentralized pattern, and finally submissive the sovereign, and very intricacies and complicacies may well pose hurdles for the first-year law students. William achieved his goal of a kingly investiture at Westminster, but duties in Norman demanded his attention. Establishing a centralized rule at Westminster permitted the governance of a large number of Saxons by comparatively few Normans. William's administrative efficiency produced a Doomsday Survey in 1086, an inventory of all property throughout England, which facilitated a much larger revenue collection. William resolved matters of royal concern at Westminster. Local issues remained the cause of shares and hundreds. Only judicial disputes of an extraordinary nature were brought before the king at chief justiciar. Administrative necessity rather than legislative design played a central role in fashioning the early structures of the common law. William's legacy was the creation of a highly centralized legal system. So we can see some points of comparison between the continental and European law. You can the basic example drawn from a property law concept. The recording statutes are now in force through the country, but it is technically more complicated and also developed in later context. So central power usually more strongly practiced in the state of European contract has some different paths of evolution involving the property laws. So it is a central and marshaled in terms of a national administration about earlier in years, and simplistic and also formalistic to ease the administrable property justice. So the different background, as you see, produce a different system of laws. So, the historical insight should be vigilant throughout the assessment of a comparative legal system, as I've focused through the classes. And in the history, the development of loyal codes are so significant to create a tradition of a common law code system. As I've introduced, you can see three essences of a common law code: a code of exchequer, code of common pleas, and a king's bench. So no separation of government functions exist in early Norman England. The king, acting with close advisors in council, the curia regis, exercised judicial as well as executive and legislative powers. The council was as mobile as the king, but some functions of the curia regis later were delegated to newly created institutions. Judicial powers assumed by the royal courts, beginning an important unification, the development of law common throughout England. The three codes, which were to develop over the ensuing 2.5 centuries, formed centralized judicial authority. They sat at Westminster even in the absence of the king. So the King's Council represents the single and united power of a king, which is divine and absolute through the country. So the demolition of council means kind of a concept on separation of powers, and the check and balances between public power evolves, which also is keenly affiliated with the concept of human rights. The Code of Exchequer, a judicial offspring of the financial side of curia regis, was the first common law code. It reflected the king's paramount interest in efficiently settling tax disputes. Exchequer's initial jurisdiction was more extensive, limited to resolving tax disputes only after the development of the Code of Common Pleas. The Code of Common Pleas resolved issues between subjects which did not involve a direct interest of king, thus the name a common pleas. The disputes usually dealt with title to land or personal actions of debt, a convenience or a detinue. It later developed an exceptional formality of procedure and became an expensive code for litigants. The third central code was King's Bench, established to hear issues with a direct loyal interest, pleas of the crown. It issued writs of mandamus, prohibition, certiorari, and habeas corpus to control question actions of public officials. So you are now on a popular terms normally experienced through right of a common law subjects, a writ of mandamus, a certiorari, a habeas corpus. All these institutions are rooted in the tradition of a king's bench. A king's bench later became an important check on abuse of prerogative powers of the king. As civil jurisdiction expanded, encroaching upon the Court of Common Pleas, encompassing most torts through the ordinarily interpreted writ of trespass and elaborate fictions, and later extending to contracts by the writ of assumption. The English barons were on the verge of rebellion due to the evolution of this common law code. Although the King's Code did not replace directly the old local share and hundred codes, if overlapping jurisdiction existed, litigants usually preferred the common law codes. Procedure was more progressive and fairer in the latter, and participants avoided the harsh proof of ordeal or oaths of local codes. This preference eroded the law of local codes and reduced revenue generated from court fees, revenue intensely coveted by both the king and the barons. One other point concerns the writ system. Which now remains partially through the modern common law system. A jurisdiction of common law court was limited severely by writ system. A civil action lay before one of the courts only where specific writ was available from a high official. Where there is no writ, there is no right. So this institution is never alienable from our routine practice in Korea also. Your first responsibility for your client would come from this context. How to shape your cause of action to seek a monetary damages or to make a legitimate plea for a exoneration. So that is important, and one of a threshold issue of technicality that the lawyers usually face. So practically, there are no distinction between both traditions, I suppose. Issued in the name of and constitution command from the king, writs were addressed to an official authorizing commencement of specific suits, later known as forms of action. The system was rigid. Selection of the wrong writ resulted in dismissal. The variety of writs, first including the writs of debt, a detinue, a covenant, repleving, and account later increased. The writ of trespass was added and expanded to encompass ejectment, a trover, and assumption, important to development of contract and tort. But these nevertheless were limited in scope, and neither the judges nor the chancellor could freely create a new writ. The statute of Westminster 1285 limited the invention of new writs to circumstances similar to those then affording a protection. To increase further the jurisdiction of common law courts, fictions were invented to extend the circumscribed writs. An example is ejectment. It originated as an action available only to a wrongfully ejected leasehold tenant and was unavailable to a freeholder. But a fiction was created. The freeholder alleged a fictitious lease to a fictitious person, usually John Doe. Doe then alleged that he had been wrongfully ejected by Richard Lowe, an equally fictitious character. Doe, the nominal lessee, next sued the ejector. The court had to determine the origin of the alleged lease, raising the issue of who owned the freehold. Thus, the common law court will rule on the title, an issue otherwise reserved to the local court. This early common law emphasis on procedure was not unlike the early Roman law concentration on forms of action, on the facts of case rather than the origination of substantive abstract legal rules. So a part of a components involving the risk system also now being enshrined in some sectors of a common law. The progressive loss of jurisdiction. We now turn to see the Magna Carta. Brief. The progressive loss of jurisdiction of local share and 100 cause induced revolt among the English barons. Joined by a similar group clause, the barons in 1215 extracted charter from King John, later to become being narrated as the Magna Carta. So we actually narrate a Magna Carta, and now a prevailing intelligence cite this document for the ground of independence or declaration in the United States. The idea is enshrined in Declaration Bill of Rights declared by a state of Virginia, and also it was incorporated into 4 headings of a independence, a Declaration of Independence. It constitutes part of a Declaration of Independence. So it was a self-serving document for the barons, who viewed the charter as a contract to hold the losses of various feudal privileges. But the charter also included a few stipulations protecting ordinary citizens, provisions which much later endowed it with a stature as a constitutional document of exceptional magnitude. The Magna Carta contributed to the evolutionary demise of rural codes, a process which continued for 3 centuries after conquest. The common law codes and the risk system were central to this demise, supported by the crown assuming ownership of all land and the diminished power of local sheriffs. The Magna Carta denied sheriffs the right to hear pleas of the crown, and the Statute of a Gloucester 1278 was interpreted to severely restrain civil jurisdiction of a rural courts. And we have one other court system called ecclesiastical courts. That is also popular in the European continent, but its actual context can differ in some context. Ecclesiastical courts persist as rivals to royal courts longer than the rural courts. The ecclesiastical courts apply canon law, the rules of which were formerly in the Roman law. The church vigorously defended its right to try religious offenses, including adultery, incest, and less distinct offenses against morality. It also assumed civil jurisdiction over family issues, principally marriage and succession, as well as criminal jurisdiction of clergy. Benefit of clergy allowed a convicted cleric to transfer the case from a temporal to an ecclesiastical court for sentencing. This unique doctrine persisted for several centuries, protecting persons with the most transient connection with church, and ultimately even anyone who could prove literacy. The jurisdictional class of church and state reached violent dimensions during the Plantagenet period, provoking the murder of Thomas Becket in 1170 in Canterbury Cathedral. Although the church largely forfeited its judicial role, ecclesiastical political jurisdiction or family and succession issues persist until the mid-19th century, when it merged with other civil matters before the royal courts. But the imprint of canon law remains to this day on English family and inheritance of law. So, okay, we now close the first half of this class, and after a short break, we'll get on the topic equity, justice of peace, and through the final of distribution. Okay, see you